Good morning, everyone. I'd like to thank you for coming to the 5-year out panel for the Communication and Law Division. Anticipating its 100th anniversary, NCA asked all divisions and caucuses to examine where the division stands, kind of the State of the Union of the division, 5 years before the anniversary. They asked each division or caucus to address kind of the history, the present state, or current trends. We have 6 excellent scholars to address this for the Communication and Law Division: Jeffrey Brand from Millikan University, Jenna Schutz from the University of New Mexico, Susan Dismania from the University of Wisconsin in Milwaukee, Deborah Worthington from Auburn University, Lynn Allen from the University of Northern Colorado, and Todd McDormand, Wabash College. And I would like to start with Jeffrey Brand from Millikan University.
Good morning. What I thought I would do is just talk a little bit about my experience with the division and where I see some of the strengths and weaknesses of our group. I'm hoping, in addition to our kind of panel discussion, we might also talk about ways to help prepare as a larger group for the anniversary. It's kind of ironic that we're in Chicago this year because 19 years ago at another Chicago convention, it's the first time I was recruited to be a part of this group. A couple of my friends hijacked me downstairs and said, "We're going to this group meeting, why don't you come along?" And so that was sort of the way I became introduced to the communication law area. And it was that experience that sort of began, in a sense, 19 years of involvement with this group. And I've been fortunate. I've had a chance to be program planner a couple of times, and I've responded to papers many times from this group at the same time. It's been a nice home for me in terms of being a part of an interest group at NCA. And I think that's one of the nice things about this group for a number of us, is it's been a consistent place for us to participate. The reason I became involved was because my research at the time involved my dissertation, and it focused on social movements and their intersection with the courtroom. So it was that courtroom perspective that made my research appropriate for this division. And I think a lot of us have gotten involved with this organization because of that. There is some element of our research that intersects the law. And I think as I talk a little bit today about what I think are some of our challenges as a group are, it's that intersection that's both a pro and con. Because I've been working as a program planner for this group a few times, I think I've noticed some various sorts of trends. And those are sort of the things I'd like to mention a little bit, and how those seem to me to impact the way our organization functions, and perhaps to allow us to think about how we can either expand on that or improve on that in various ways. And I suspect I'll probably hear some very similar comments from other people on the panel too, so I won't elaborate too much. First of all, I think one of the interesting things about our group is we're bound in part by a common interest in the law, but that interest extends to almost every other division at NCA. And so there are legal topics that intersect almost every other area of research and almost every other interest group. And so although we don't have, in a sense, a distinctive area of research, as some interest groups might claim to have, we have at least a way of connecting with many different parts of NCA. In some respects, that's an advantage, but it's also a challenge because, sort of like in my case, you come and go in this organization in part based on whether your research at the time is concerning a legal-related topic. A second thing, though, that I felt, especially when I look at the programs, I look back at the programs I've worked with over the years, is that we have been successful at drawing together a diverse group of people. Especially when we put together panels of papers and top papers, we get people who are doing research in many different areas coming together in one room. And so it's been an opportunity for me to be exposed to research in other areas of the discipline. And I think that's one of the strengths of some of our panels, is because we don't just hear from one small slice of the field, but in many cases, many different areas. Another thing I've noticed in terms of these panels is that, for me at least, a lot of what we've done has helped me as a teacher. I teach courses in law and culture, and I teach courses in public relations and the legal end of that, and I teach in the area of mass media law. And I've learned a lot and gotten great ideas from this panel as a teacher. And I think a number of us, and we've also successfully as a group had a number of panels on teaching legal issues in the classroom. This has been a wonderful resource for that as well. And not all divisions, I think, at all times, at least keep a lot of awareness of how what they do impacts teaching, especially at the undergraduate level. And so I've benefited a lot, I think, from that at the same time. One of the things I think is a challenge, though, is I keep thinking about who else we can bring in and how we could be more active in bringing in scholars. Every time I go to a convention, I walk through the book section. There are a lot of wonderful new books about something that deals with the law, whether it be the Supreme Court, whether it be a rhetorical criticism approach, whether it be current topics in politics. And I look at the authors, and I don't think of most of those authors participating in our group very often. And I know there's a lot of scholarship out there, but I think some of it, especially in the publication areas, doesn't always reach our area. Another challenge I think sometimes we have in our division is because of our area of interest, we also don't have perhaps a journal or many other specific publication areas that people who do the work we do are a part of. So in some respects, we are very effective as sort of what I would call an affinity group. A lot of us have an affinity for legal studies, and we get together and celebrate that. And we give people a way to express and publish or at least present that information. But at times, I think our numbers come and go as a result, depending on people's areas of research. So we have, I think, a lot of challenges in terms of continuing to be an active, dynamic group, and I'll let some other people talk about that too. But I also think we have a lot of strength in terms of what we can offer to a lot of other divisions. So I'm going to move on and let Janice talk next.
Thanks. I took a different approach than Jeff did, and I'm glad Jeff kind of gave the history. What I proposed to do for this panel was look at sort of the past, present, and future of theories in legal communication. So that's my focus, and I've been in this interest group since it was founded in the early 1980s. So I'm an old-timer in this group, and I'm very interested in theory. And what I'd like to do is talk about 5 theoretical traditions that I think will be ongoing traditions that are important for scholars in this area. And the first one, it goes way back to the forensic genres, Aristotle, Cicero, and some of the early ideas in the classical tradition I think are still important. They need to be reformulated, appropriated, and added into new theories. But things, for example, like topoi in Aristotle, stasis in Cicero, I think are still relevant to the study of legal discourses. A second tradition that I think is important and will continue to be important, because I have a background as a trial consultant, as I'm sure many other people do who are on this panel, is the whole area of practical persuasion, the sort of how-to theories of legal communication that are based on successful pretrial and trial practices in the U.S. and in the British Commonwealth countries. And there's been a lot of interest, continues to be interest. I've just been doing some consulting with trials in the last couple of weeks on what I call normative theories of communication as they're applied to the courtroom. And I think that these kinds of theories are important because most law students still do not get very good training in communication at all, whether it's conducting the legal interview, whether it's helping with a settlement in a civil case, whether it's taking depositions, whether it's working in the criminal trial process. They simply do not have much communication training. And those of us who visit court a lot are pretty much aware of that. I think it's important in these how-to theories of persuasion to look at how communication constrains and is enabled by legal rules. And these how-to theories, I think there has to be this intersection of legal rules, procedures, and protocols with communication practices. And I think that these persuasion theories help us to understand those, whether it's simple little theories such as primacy, recency, inoculation, forewarning, boomerang effect, those kinds of things we get out of traditional persuasion theory that have been applied to legal practice. I think those kinds of studies are going to continue, along with the how-to theories that come out of persuasion are the theories that come out of sort of performance and drama, the law, certainly courtroom law, litigation is performative, and it involves people persuading by what they say and do and how they say it, and by strategic and tactical maneuvers in the courtroom, whether those are under the rubric of nonverbal communication, or whether they're talked about in terms like Goffman-esque terms of performance. I think that lawyers, attorneys, judges, and witnesses are there to make an impression on the jury, and or on the judge, and that impression is still important in the theories of legal communication. The third area that I think is important and that we haven't done that much with in our discipline is the theories of language, looking at, and this draws on some of the early work by James Boyd White, that emphasizes law is language. I think we need to look more at technical language that rule-governed forms and structures that try to convey the impression that the law is authoritative and impersonal. That law relies on action language. It asserts, alleges, builds records, renders judgments, issues summons, overrules, sustains, enforces, remands, nullifies, and punishes. The language of the law is extremely potent, and it's through the language of the law that people are supposedly brought to justice. I think we can look a lot more at speech acts, we can look at rhetorical pronouncements, and we can continue to look at some of the early stuff that was first done by Haig Bosmagen, and David Birdsell has done some wonderful recent research looking at tropes in the courtroom, whether that's synecdoche, metaphor, personification, satire, ideographs, allegory, and how those elements of the law are configured, whether it's in trial practice or whether it's in judicial opinions. A fourth area is what I call discourse studies. I think it's important for us to study the elite discourses of the law that are primarily designed for professionals who understand the technical language of the law. These elite professional discourses can be explained and have been explained in terms of critical theory of marginalizing the powerless, silencing the voices of those affected by the law, and reifying the power of the courts and legal professionals rather than serving the interests of the people and the interests of justice. And I think critiques of this sort are becoming more and more prevalent, and I think they raise public consciousness about the power of legal discourses to control and subjugate people rather than do justice for them. I think we need to continue to look at representational discourses, popular culture and its representation of law in novels, documentary films, fictionalized television dramas, reality television like CSI, have significant influence on public understanding of legal communication. They influence public literacy about the law, and because they influence public literacy about the law, they influence people's ability to serve on juries, to find counsel, to understand what's going on in the legal system. A lot of these people are publicly elected people. They're paid for by taxpayers. And I think that the representational discourses of public culture have a tremendous effect on how law is practiced and how justice is given. And this, I think, needs to extend beyond some of the traditional things that we've studied, like pretrial media publicity or cameras in the courtroom. I think these representational discourses have a huge impact on the law, people's understanding of the law, on the reputation of judges and attorneys, on people's ability to serve as witnesses and those sorts of things. Another kind of discourse that I think is important is what I'm referring to as prosaic discourse. This is the way people in legal settings talk about the law, or the way we in just everyday conversations talk about the law. People frequently talk about the laws if they've had direct experiences with it. When they haven't, they construct strong opinions about the law and legal processes, such as the importance of wealth in buying justice, the racism of the police, the frivolous nature of civil lawsuits, and the likelihood that legal proceedings are tainted by judicial and attorney biases. I think we haven't pursued this very much, but I think that people's talk about the law outside and inside of the courtroom is an important area of study for the future. Some of the work that's been done by William Obar and other anthropologists have looked at the consequences of language in the courtroom, particularly the powerless and powerful speech or narrative and fragmented speech of witnesses. Many of the discourse theories are critical. They try to raise people's consciousness about the law, and I think the work that's been done by Maruf Hussain and Dale Herbeck and others reports this. The last one I had was narrative. I won't go into that. But I think that there are a number of theoretical traditions that we need to pursue, and I, for one, believe that legal communication research needs to be grounded in theory, and that was the purpose of my talk. Thank you.
That was a good introduction to some of the topics that I wanted to raise. I wanted to advocate for anticipating the 100-year anniversary of the field by calling for more law and communication research to be done outside of the legal system and to look outside U.S. borders. My own research has focused on victim-offender mediation following the restorative justice tradition, and so I came into the law and communication area as somewhat of an outsider, looking at how mediations take place in post-conviction cases. So the cases that I looked at were victims of violent crime who met with their convicted offenders, sometimes 20, 25 years after the crime took place. And I looked as a discourse analyst at how victims and offenders talked about apology and forgiveness in very intense emotional encounters. These small micro studies of interaction between victims and offenders then led me into a broader understanding of the criminal justice system in the U.S., to look not just at courtroom interaction, but to look at what happens years after a crime has occurred. And I was trained as a mediator and mediated cases, worked inside the prisons, and gained a great understanding of how legal processes that happen in the courtroom expand outside into society. And that's really shaped the way that I have understood law and communication as part of a societal discourse affecting victims and offenders in very personal ways. In the last few years, though, I've had the opportunity to travel to different countries, and I have found that the experience of the U.S. criminal justice system, as I've studied it, has been very valuable in looking at some pressing legal problems. For example, over the last few years, I've looked at a transition in Mexico that's moving from a system of written trials to an oral trial process. It was just put into legislation in 2005 and began in different states in Mexico in 2005, but by 2008 was adopted through Mexico's legislature to occur now over the next few years. By 2016, there will be oral trials in Mexico. And that's a major shift in the way that Mexico will deal with crime. Part of the impetus for this change from the written legal system to an oral trial system is because there's a lot of corruption in Mexico. There's inefficiency in the legal system and a need to move trials through a process much more quickly. So the oral trial process offers the hope of maybe moving some process that might take months to accomplish, to convict someone for a crime, to doing that in just a few days or hours. And so that's part of what Mexico has dealt with. There's another part of the Mexican story that I think is interesting as a communication scholar, and that is the hope that oral trials will bring transparency to the Mexican legal system. And so you see everywhere from the inability for people to even report a crime. It's estimated in Mexico City that only 80% of crimes go unreported, and the ones that are most reported are auto thefts because the insurance companies require that you have a police report so that you can make an insurance claim. So corruption and transparency are arguably fueling this change for an oral trial system in Mexico. But as communication scholars, we have a real opportunity to help and assist Mexico. And indeed, there are some groups already, both in law schools and with U.S. government assistance, to help train and develop the legal professionals' communication skills, both lawyers and judges. When I went to Mexico, I was hoping to look at how victims were communicating in the courtroom, but it was apparent that they weren't quite there yet. And that the real emphasis is on training legal professionals to provide the structure to have the oral legal process. Everything from constructing courtrooms to developing the procedures that capture the trial. In Mexico, they're doing some really interesting work with cameras in the courtroom. So instead of having a transcriber sitting in the courtroom, you have video, which gives discourse analysts like me a lot of data to work with. And so I'd like to advocate that in our field we look across borders to see how these systems are changing. And that's not to say that we're there to impose our own U.S. perspective on what's happening, and indeed that's not the case in Mexico. They're not looking to adopt a trial system that would be like what we have in the U.S., but they are looking to some of the communication skills that we have to help train their professionals. I'm currently based in Sweden right now, and I've been really interested to look at how victim impact testimony is being debated. Here in the U.S., we talk a lot about victim impact testimony and whether or not including victim discourse into the courtroom somehow disrupts the objective trial process. And there's some very interesting experimental studies that have been done to show both that, yes, you can encourage a death penalty conviction by having emotional victim testimony in the courtroom, but there's other research that suggests that may not be the case. As you humanize a victim, you also humanize an offender through testimony that might include emotional responses, and that can sometimes lead to not convicting or resulting in death penalty. And of course, death penalty is one of the areas where people are really looking at victim impact testimony because the consequences are so great. In a European context, though, there is a very keen interest by scholars I've talked to in the American experience of what the victim rights movement has provided us in terms of what the role of a victim should be in the courtroom. And again, we as communication scholars, I think, have a lot to offer in terms of understanding and preparing, even on a practical level, preparing victims to speak in the courtroom. As we look ahead in the next few years, I think there's some interesting areas where we could help change the course of some major shifts in legal process, particularly in Afghanistan and Iraq, where there's a lot of interest in finding rule of law experts to help build new legal systems. And I hope that those of us who are in this field can offer our assistance where possible. I've been really energized by my work in the law and communication field, even though I'm not a lawyer, and have found it to be a nice home for someone who is a discourse analyst and who really finds a lot of interesting areas to work on in the field.
My name is Deborah Worthington, and I have been, like Jeffrey, a member of the division for quite some time, since the early 90s. And I approach it from a slightly different perspective in terms of when I first joined the society, there were a number of scholars who were doing quantitative research who presented as part of this particular division. And since that time, one of the things that I have seen is that the amount of quantitative research that has been submitted to the division has decreased significantly. And the fact is that I know that research is being done in certainly in legal communication, but at the same time, it seems sometimes to be presented in other divisions. And so, for me as a quantitative scholar and looking specifically at legal communication, I would like to certainly see the division perhaps reach out to these scholars and invite them to present, as at a place where I really feel that their research would be quite welcome and really would be at home. So reaching across divisions, if you will, or disciplines within NCA is one place that I see that we need to go. But in some ways, perhaps more importantly, I think that we need to be reaching across disciplines in terms of, say, psychology and sociology and other areas is that. Okay. And I will give you a personal case in point. I had an attorney call me up a couple of years ago and say, I really have this feeling that the way in which the videotape is being done for my witness depositions has an impact on how jurors are perceiving them when these depositions are presented in court. What do you think? And I thought, well, this is a very interesting question. It's not one that I had considered. It certainly has, strong communication overtones. And so I sat to do research. I sat down and started doing, just a general literature review and background on it. And what I discovered is that in the realm of psychology, specific to criminal trials, there is a wealth of research that is being done that have communication overtones. And it's the type of research that we as communication scholars should be doing. And it's being done in the field of psychology. And so certainly the psychologists bring their particular perspective to it, and it's a valuable perspective, but we as communication scholars have something that should be offered certainly as well, and that those perspectives are not being reflected in the research. Okay, so certainly I've begun doing research in this area and have been presenting it, and hopefully will be publishing it soon. But it's just a case in point on the type of research that we should be doing. And I think we should be doing more of as communication scholars. That said, I think it's also important for us, and we see we can see this certainly in our daily lives as teachers as well as researchers, is that in many ways we should be reaching across curriculum. We should be reaching across disciplines and taking the wealth of these different areas and adding them to certainly our own research. The other primary thing that I wanted to speak about as well, okay, and Jan touched on this briefly, is the idea of contributions to the community. And this certainly can be done in a number of ways. In our classrooms, it can be done with regards to service learning. As scholars, it certainly can be done in terms of pro bono work. I have my students work on service learning projects, and interestingly enough, it can be done across disciplines. So, for example, the political science department has their pre-law classes, and having these students who want to go on and be attorneys learn about the perspective of communication scholars from communication students as they work, towards mock trials in their classrooms and things of that nature is one area. And I call it service learning, even though it's not to the greater community, but I think it's important for these attorney wannabes to see that there are people out there who have a perspective that perhaps in some ways almost gets trained out of them as they go through law school. I remember my advisor when I was finishing up with my PhD, I actually considered going on to law school at that time, and he looked at me and he said, "Your greatest strength is that you do not think like a lawyer." So I think that certainly is an important idea for us, as one of the areas that we can do is work either consulting in either, whether it's paid positions or it's pro bono work, that we can contribute in that particular way. The other thing, and I know this was a discussion with regards to the Legislative Assembly on Wednesday, deals with whether the NCA should take political positions or not. Okay. And one of the things that the American Psychological Association does is, based on their research, they do take political positions. So, for example, going back to the research that I just mentioned with regards to camera perspective and the impact that the camera angle may have on jurors' interpretations of interrogations. They recently did a white paper that essentially provides best practices for police in terms of the ways in which they set up the cameras and under which the interrogations are done. And so on, because the research shows that it does make a difference in terms of people's interpretation and of the types of events that occur, and how much what is the word that I'm looking for? How much control, where the locus of control then lies. Is it more with the interrogator, or is it more with the accused? And simply changing the camera angle can change people's perspectives of that. I think it's a very important point, and it's one that through the research and it was very well done research through the American Psychological Association, they developed this particular white paper. And I think that's the type of thing that research-based white papers in terms of best practices are the types of things that we as an organization, I think, can, and I really do believe that there are times when it should be done. Okay, I'm not speaking in terms of the recent discussion with regards to torture, but just the general idea that there are best practices that we can put forward in the legal field. Okay.
At the heart of liberty is the ability to define one's own concept of the meaning of existence, of its memories, of the universe, and of the mystery of human life. From the Supreme Court decision Planned Parenthood versus Casey, I take the mantra anticipating the anniversary of the Legal and Communication Division 5 years out. I turn my attention this morning to brain fingerprinting. Thank you to Jeremiah Hickey for making our panel possible and for the contributions of those who have preceded me in their remarks this morning. Jeffrey Rosen, in an intriguing New York Times Magazine feature several years ago, around the time of the hearings for now our Chief Justice, wrote about the questions that are asked of a typical Supreme Court nominee versus the questions that justices will have to anticipate in the not too distant future. One of those areas that Rosen focused on is that of brain fingerprinting. My research this morning turns to a particular aspect of brain fingerprinting, the murmur device. In this device, devoted to memory and encoding-related multifaceted electroencephalographic response, you have a case where a witness or a defendant might be called to the stand, offer no testimony, make no statements, and yet have brainwaves recorded into the record determinative of whether or not that person was present or absent from a crime. Brain fingerprinting, quite simply, is a binary detection system to determine presence or absence. Is something stored cerebrally or is it not? And the technology has been rather amazing in this regard. And through a headband being attached to the person in question's scalp, and the response either to words or to images determines whether or not that person has recorded, has stored cerebrally indications of their presence at or absence from the crime in question. This raises many interesting questions about the right not to incriminate oneself, rights of due process, rights of privacy, inferred at least constitutionally. And from a communication perspective, I'm particularly mindful of what Janice talked about this morning, how our communication theories need to really drive some of this research. So I have coded analogically the kinds of descriptors that are used to try to determine whether or not this brain fingerprinting ought to be a criminal detective tool of the future. In that construction, I have asked whether or not analogs exist to describe this new practice. And I have concluded that 3 major types of analogs do indeed exist. I label these as prime analogs, that is, the new analogs attached to brain fingerprinting itself. Secondly, I label them as precedent analogs, so going to precedential decisions as cited by the Supreme Court with regards to the rights to person, property, memory, consciousness, and so forth, what kinds of precedential analogs emerge. And then I go to pre-configured analogs that go to earlier detection devices such as polygraphing. And in looking at those 3 corridors, quite simply, I am able to determine that 2 major analogs predominate in all 3 of those constructions. And those are the analogs of memory as storehouse or memory as storekeeper. When we have memory as storehouse, you are looking at essentially search and seizure questions that might be more correlated with Fourth Amendment considerations. And insofar as the memory is a storehouse, it is analogous to or akin to a territory to go in and with proper warranting, search, investigate, try to determine whether or not within that storehouse something has been cerebrally recorded. Now, within that, you have the picture of the terrain of a brain as existing as artifactual testimony. It's something independent almost from the one who would gather the thoughts, live the life, experience the memories, and all of the tribulations and tremulations that might go with that. And in mapping the surface, there are very descriptive analogs. One writer, Hennig, describes it as like trying to get to the moon by climbing a tree. You think that you're ascending ever higher, that you're seeing something about the brain unpreviously detected, but the higher you get, even if you ascend to the very top of that towering pine tree, yes, you're closer to the moon, but does it really tell you about the terrain that's being mapped? Others will talk about transgressing or transferring onto that territory more as the old story of the blind man and the elephant, where you might see different aspects of the brain, just like you would see the trunk or the tail of the elephant, and infer from that certain qualities. But what if the elephant gets in mud prints? And then what do you have as far as all of those contextual memories that surround the memory in question? So many of the metaphors go to the idea of brain simply as this regarded territory, and how do we navigate the territory? Fewer of the metaphors go to, or fewer of the analogs go to, brain as storekeeper. So what is it to actively engage in life, to accumulate, to sort through, to privilege certain memories over others? And when we are the storekeeper, then how do our Fifth Amendment rights get encoded? If we have the right not to incriminate ourselves according to our Fifth Amendment to the United States Constitution, then what do we do? These discussions are not far off. The technology is increasing as we speak, and legal discoursers, analysts, and participants of the future are going to be confronted with this, and I contend that to know about brain fingerprinting and the analogs that are being used to support and to refute its use, even unto terror detection and Quantico, that as we look at the maps, the memories, the mantra of our life, the measurement through brain fingerprinting will indeed give us that privilege of the power to order the memory, the power of murmur, or the power of refraining from that murmur as it encodes who we are, the power to encode and determine the meaning and the mystery of one's life.
My name is Todd McDormand. I'm from Wabash College. My comments are most similar to what Jeff had to say at the beginning of the panel, and then in my few minutes, I'd like to talk a little bit about communication and law, and in particular, what I see as the health of the Communication and Law Division in NCA. So in these comments, I offer one member's perspective on some of the challenges that I think face the division, and then what some of our promises and prospects might be, some potential paths forward. And I would again stress that it's one person's perspective, and as I'll say probably at the end again, it is slanted toward what I know, and it's different than what other people know, and they would come up with different lists and equally valuable, if not more valuable, lists of things that we might do. So I've been attending NCA since 1995, and I've been part of communication and law since that time. So I've got some experience, but not as much as many others. During that time, I've served as program planner. I regularly respond to a panel at NCA. I respond to the submissions, things of that sort. I say that not as a claim of authority, but of participation, and that I've got at least some perspective on some of the things that have happened in this division the last decade and a half or so. Overall, it strikes me that the Communication Law Division of 2009 looks quite a bit like the Commission on Communication and Law of 1995. I think we're in a pretty similar place overall. And while I'm under no illusions that this should be one of the biggest divisions in NCA, I do want to start by briefly identifying what I see as four of the challenges that face this particular division. And one of those has already been alluded to by both Jeff and Deborah, and that I think that the work in communication and law is easily subsumed in the work of other areas, including the public address division, rhetorical communication theory division, of course, freedom of expression, where I haven't seen membership lists, but I imagine that we share a substantial number of members across those two areas. In addition, we have scholars who do work in the area that aren't affiliated with communication and law really at all. And I think that's one of the challenges we have in establishing a critical mass. A second challenge I think we face is that the division is regularly visited by a number of people as they contemplate the communication field. And then for whatever reason, they don't persist. And I think that's because they pursue a different area of specialty outside of communication proper, or at least outside of as an institution, as they continue their legal work. A third challenge we face is that our area has particular obstacles in terms of some of the specialization and some of the intimidating knowledge that is there at times. I think that might be why we don't see more papers submitted specifically to our division when we do see across the program a lot of papers that deal with law, because people don't know if they want to submit it to the division that has law in the title, because maybe that means you have to have this really specialized knowledge. But if I send it to the one that has public address in it, well, they're really going to look at the rhetorical theory and not the legal stuff, so I'll be okay. So I think that is intimidating. Finally, I think we have a challenge related to the greater challenge of NCA, and that is, as our membership has continued to grow, we've also become more balkanized, more specialized. I'm not sure how many units there are in NCA now. I think over 70. And each time we divide, we become more specialized. And niches are valuable, and I agree we're a niche. And yet I think increasingly we're separating from ourselves all across NCA. I don't know what the special solution to that is, but I do think that's something that's happening here. So what can the Communication Law Division do to, if not grow, to improve its presence? I think that there are limitations in what we can suggest, the greatest of which is that we all have a limited amount of time, there's also a limitation that no one person can do all of these sorts of things. But I do think we could do things to make our program offerings maybe more relevant, but certainly more intentional. First, I do think, and a couple panelists have alluded to this as well, that the division should continue its practice of offering a panel devoted to teaching approximately every other year. Over the past decade, I've participated or attended 4 such panels, and I feel confident in saying that those were the 4 most attended panels from our division that I have attended. We have a lot of energy on the teaching panels. I think it's a testament to our work as teachers, and to me it underscores that that's really our strongest common link. We come at our research in communication law from a variety of angles, but we all seem to come together when it comes time to talking about teaching pedagogy and ways to reach our students. And I think that's one of the strong facets of our organization that we should be sure to continue. Second, I think we should try to more consistently reach out to the legal community and practitioners. We've certainly done this periodically, depending upon the host city. I think it's something we should continue to do on a more consistent basis, and bringing in judges, trial consultants, various sorts of practitioners. I think there's a lot that we could stand to learn from them. And then I think at times there's a lot that they could stand to learn from us as well. And I think those could be valuable conversations. NCA's policy on visitors isn't always the most friendly and conducive to this, but I would hope we wouldn't let that be too much of an obstacle. Third, I've encouraged an annual or biannual panel on the work of the Supreme Court. I mentioned this in the division meeting yesterday, where we could have a panel of scholars. Each has selected a hot-button issue from the previous court's term and have a discussion panel that talks about the implications. Related to that, we could also spend time reviewing the work of particular justices, a new justice or new justices as we currently have, the career, legacy, and rhetoric of a retiring justice like Justice Souter, or a practitioner. And I think here of someone like Morris Dees of the Southern Poverty Law Center, has a long career of public advocacy in the law that I think would make for a fascinating panel from our unit. Fourth, I think we should offer a panel that would celebrate the best work in our area. And we do a good job of producing panels on in-progress research, and that's very important to all of us in terms of our faculty development. But it does strike me that there's a lot of published research in the area that we don't do a lot with, and we don't have affiliations with those scholars. So Maruf Hassian won several awards with his book, which book, right? In the Name of Necessity, a rhetorical analysis of military tribunals and the loss of American civil liberties. Trevor Perry Giles' book on the Supreme Court nomination or confirmation process a couple years ago, a very well recognized book. Clark Roundtree's book on Bush versus Gore won the Horace Campbell Prize this year, and rhetorical criticism. These are valuable works. They're timely works given the transitions on the Supreme Court, given the continued discussions of detention and tribunals, and I think we could do more to celebrate those works with panels devoted to them where we discuss and respond to that sort of work. I'd like to see us do that. The last idea, actually I have 2 other ideas. I guess this is fifth. We should consider the idea of a pre-conference. We haven't done that, to my knowledge. A way to bring all of us together over a sustained period of time to talk about either a specific topic or in-progress research. I think it might be a way to help establish a sense of shared identity and also a sense of energy when we aren't competing against everything else on the NCA calendar on a given day, and I'd encourage us to think about that. And my last idea has to do with how we honor our work. We have traditionally given recognition to the top paper, top student paper. I think those are valuable recognitions, particularly what we do for the top student paper. When someone is about to enter the job market, it gives them a piece of credibility. It gives them another symbol of a sort that they can call upon. But I wonder if we might also want to expand that to consider ways to recognize a top article or book chapter in the field, or even a top book in the field. And I say that because those sorts of recognitions are not only valuable evidence of scholarly productivity, but they can be useful to our members as they go through performance reviews of various sorts. And particularly in economic climates such as these, they can be valuable when we have to defend our scholarship and even more so our travel. Certainly, we don't have resources, so it's normally a line on the vita, a pat on the back, and a round of applause But I think those are valuable nonetheless, and I would encourage us to consider that. So I think these are ideas I'd like to see the leadership of the division take up. At the same time, I think that they need help. The program planner in particular has enough to do in any given year in learning the system and working through and organizing the sessions. Maybe someone could help with special panels. Maybe someone could help with the idea of awards. But those are some ideas that I throw out for discussion. And again, I think there are other equally good, if not better, ideas that people can talk about from an empirical angle, from trial consulting angles. I spoke about what I know, which means I focused on rhetoric, but certainly there's a lot of other areas about communication and law. And I hope we can move forward productively. Thank you.
Once again, I'd like to really thank all of the scholars to present their ideas to us today, especially to do so in a very short time frame. I know that's always tough to do. We heard a lot of good ideas about the Communication and Law Division. We heard a lot about the strengths and challenges that we face, the diversity of our division, even the practical application of our division. I think it would be best at this time to extend the discussion to the audience with the scholars. What ideas did you like that they address? What did they not address?
I just wanted to ask, this has nothing to do with, per se, the ideas that you had, but, and I missed the first speaker, I'm sorry. How many submissions of papers do you get for NCA? What is your acceptance rate? And so I could get some idea. I don't know why I've never belonged to this division, but I should.
This year there were 31 submissions and 31 papers, and then 4 panels. 3 panels were accepted and 16 papers were accepted.
I'm not at all familiar with the division, so this is a very naive question. Can you talk about ways in which you do or might interact, for example, with the American Association of Law Schools in terms of developing professional education of lawyers and what you might contribute to law school pedagogy?
We had a panel 10 years ago now in Seattle where we had the dean of the University of Seattle Law School on a panel to talk about some of the relationships between communication and law. That's a very brief example. I want to say maybe some of what Deborah's done when she's been connected to people might speak more to that.
I don't work with law schools per se. I've been a member of the American Society of Trial Consultants for just about as long as I've been a member of NCA. It's primarily a professional organization. I'm one of the relatively few academic members of it. I've been a longtime member of the research committee, been on the board as well, and so on. And one of the things that we have consistently tried to do as part of the research committee and as an academic is we try to make connections between the research that's being done and the practice that trial consultants do. So sometimes it is, this last year I went in and I talked about the camera's perspective research that I had been doing, because certainly they do a lot of witness depositions and they do a lot of witness preparation training. As well as a few years ago, we had a top 10 hit list, if you will, of the best research. In other words, the research that, as we put it, trial consultants should be reading in the raw. In other words, they need to go and they need to read the original, research in these of these particular articles. Other things that they've done in the past is, for example, in their they have a newsletter that goes out to the membership, and one of the things that they have done with regards to that, and I've contributed to this many times, is translate current research into a form that is, sort of easy to read, more, lay terms and things like that for full-time consultants. And we see they've started a professional publication that's really aimed more at attorneys than it is at other consultants, but they're in many ways doing the same thing, is trying to translate what it is that we know, that we've learned, into a way so that attorneys can see the value of it. And so they become sort of a mediator, if you will, between what we're learning as academics and the type of research that we do, and then translating that to attorneys so that they see the value added of the type of assistance that trial consultants can give. I would think that we probably could do, in many ways, the same type of thing with law schools. When I was at the University of Kansas, the legal communication class, at least half the students in the class were law students. And they were strongly encouraged to come up and take courses in the communication studies department there. It's nice when you can do that when you have a law school attached to you. Auburn does not have a law school attached to it. The law school is associated with the University of Alabama, which makes it more difficult for me to do that. So what I do is I just wait for attorneys. We have a speaking bureau at the university. I'm a part of that speaking bureau. And so I use those opportunities to talk about, what the research says, those sort of practical, I call it best practices. So if they're not hiring a consultant, they can at least then discuss, the types of things that I can give them in a short form and hopefully translate that with their clients when they're working with them.
Can I just add one?
I just wanted to add one little bit. We haven't done it for quite a long time, but we have done continuing legal education for attorneys as part of the conference, and the presenters were all communication professionals. And I think the last one we did was in Atlanta.
I think one of the advantages from an education standpoint is we have oftentimes a lot of pre-law students at the undergraduate level, and we like to at least believe we can introduce them, like we say, before it gets trained out of them or whatever, that they can at least see the communication dimension there. So I think that's one of the valuable things we do for pre-law law students as well.
Just really brief, I teach at a law school. I'm really a joint appointment in law school, and it strikes me that there are a couple of areas that maybe, and it sounds like it's happening, but one area that might be of interest is as law schools revisit the legal curriculum, which is happening all across the country now, especially in light of changes in dispute resolution practices, restorative justice, which is asking some more fundamental questions about the law and the role of the lawyer in society. That may be a real good opportunity for intersections in influencing the curriculum. The other piece is just a very simple one, and that is, and maybe you already do it, it sounds like you do with your newsletters and so on, law faculty who teach in areas that touch on your area of scholarship, ways to connect with them that helps influence their work in the classroom with law students.
I find that my association with the American Society of Trial Consultants does two things. One, it allows me an opportunity to talk about the research in the field, whether it's research I've personally done or research that others have done. The second thing, and for me personally in terms of a researcher, is I get fabulous ideas from them. One of the papers that I presented yesterday was on the role of audience response systems as a means of collecting data. More and more trial consultants are going towards that. But the question was, does the use of the technology in and of itself affect the results that you get? And so that was a study that was born from a conversation at lunch one day while I was at the conference, and was one that is now in the final stages of writing it up and getting it out. And so it was, I find it exciting to go just for that type of interaction, because they have very practical questions that sometimes we just don't think about because we're not there every day doing it. Because even though I've assisted with consulting and have done that on and off, for 20 years now, it's not the same thing as being in the trenches every day and having someone ask that question or facing that problem and not knowing, having an informed way of making a decision, about it. So
this may just echo a lot of what's just been said. But, I've tried cases for 20 years. My wife teaches in a law school, and so I'm a little bit in touch with what's happening now. I was in law school 25 years ago, but. Echoing what Janice said, I don't think students really learn much, if at all, about communication with juries, especially in law school. Yes, there's usually a trial technique class, but that's often a third-year elective. So there's a tremendous opportunity, I think, at the undergrad level to focus on communication skills and to study and research in the area. I have had tremendous. This is my third year teaching. I love it because after practicing for 20-some years, having a chance to step back and look at the theories and see what I was doing. Many of the tricks of the trade that we kind of learn are just because they worked. And we'll do that again. But there's been no research on it. But I think students love it. And for those who may be intending to go to law school, it gives them an opportunity to get very much involved in performance skills. So I'm just excited about this, and to the extent that I get on listservs and touch base with some of you, I'm also looking for teaching materials. I use my own. I've looked at the college, or excuse me, law school, trial technique stuff, and it's not really applicable, I don't think, to undergrad. So I'm interested in either developing or learning about stuff like that. So I'll be getting in touch with some.
Have you taught or developed any sort of moot court program or exercise through what you're doing? I mean, that's one avenue that you might be able to use.
I think moot court is certainly something that they can get a lot more of in law school. But to me, it's more fascinating to try to connect with decision makers dealing with deciding issues of fact. In other words, juries, non-jury judge trials, arguing cases in a moot court context isn't as exciting to me because it's, like most people say, the judges already made up their minds. Maybe you can pull them one way or another. But the whole persuasive process that occurs in a trial on an issue of fact is what's, I think, great fun to learn and to teach and to study. So yeah, no, moot court doesn't.
When I teach courtroom communication at the University of Northern Colorado, I have two juries that hear the case. And then they don't know which is the real jury and which is the deselected jury. That's been coded in an envelope that remains sealed until an appropriate time, that then they're sent to do deliberations separately. And it's very interesting when they come back to see, A, whether they've reached the same verdict, and even if they have, it might be based on a different reason, based on a different piece of the persuasion process that occurred, or they might reach different verdicts, and then how do you account for that? So I think that's really a great revelation. It could be used out in the field as well. I know that they do these scenarios that you've talked about in your researches with the mock trials, and to have juries hear that very same testimony in that same context, and then the way that they play that research out, the way they play that evidence out when they're actually confronted with making a decision about it.
Other questions from the audience or from the panelists to each other?
Yes, there are so many aspects of the theory and the practice. So how do we make our discipline known, not just as here are sets of techniques that you can put into play, but there is a real theoretical grounding that goes back to the days of Aristotle and Plato, a real theoretical grounding. How do we do that and not lose that audience who wants to know, what can I take into the court? I'm busy, I've got my cases to assemble. How do I make sense of this theory?
That's why I suggest it gets done at the undergrad level. Because when you're practicing, you just don't have time to focus on, anybody familiar with McElhenney's book on trial technique? I actually used that throughout my practice when I was looking for ways to have a novel way to approach something. But there just isn't time, which is why I like the undergrad opportunity to just go over, spend some time in initial course where they get exposed to the basics, and then have an advanced course where you can just sort of drill them on stuff. And anyway.
Jeff mentioned, or started off by noting that there isn't a central publication, scholarly publication outlet for us. Do we think in the next 5 years we'll be closer to being able to make that happen? Or?
And I think the Communication Law Review is really, it's traditionally more oriented toward First Amendment, but it has opened up in recent years. And I've seen a number of pieces in it, and I wonder, and I say this guiltily, because I've never submitted something there. So I wonder if it's something that people in this division couldn't engage with more. It's mainly online. I'm going to mess up the name. It's David Dewberry. And he posts on CritNet fairly regularly each time that the new issue's out. So I don't know what the prospects are for a different journal, but I think that's one that people in this division and the people in this area of research could make better use of. And maybe some of the panelists here have published on it. Like I said, I haven't submitted.
I've published in it, and actually twice. And to be honest, I didn't know about it. You get so focused in on the ones that, for me, most of the journals that I have published have been outside of communication because they're much more receptive to the type of research that I do. So that has been law and human behavior, behavioral sciences and the law, law and public policy, and things of that nature. In fact, I made jokes for a really long time that before I went up for full, I had to get at least one journal with the word communication in the title. And so, but there were very good reasons for going, because those are the ones that are read by scholars who do the type of research that I do. They tend to be more receptive to it and so on. But he actually sent me an email and said, I've seen some of your stuff. I saw a panel that you did. I really think that your material would be a good outlet for this, and sent me the link, and I started looking at it, and I'm like, this does make sense to publish and to send things for for review. And so we discussed rejection rates and things of that nature, because certainly that's of importance to me. And so I eventually did send in a couple of articles. Well, I think one came out last year and another came out this year. So I've had a very positive, obviously not just because I was published in it, but a very positive experience in terms of the review times and things of that nature with the journal. It is an online journal, and I realize that depending on where you are, some programs are going to be more receptive to online journals than others are. But my program seems to be fairly well receptive of it, and so I went ahead and sent the material into it. So,
what's the name of that journal?
Communication Law Review, I think.
Yeah, Communication Law Review.
And I think most of the traditional communication journals are pretty receptive to legal research. I haven't had any responses to say that your work falls outside what we do, and I review essays on a fairly regular basis for a couple different pretty prominent journals when they have law-oriented rhetorical pieces. So I think they're pretty receptive to it. So we might not have a lot of specialized journals, but I think there are a lot of communication outlets that we can take advantage of.
I think the idea of, like you were saying, though, to celebrate that line of scholarship more, so that people see that this is not only an area of research but also a published area of research, regardless of whether we have a single journal. And maybe, as you were saying as well, to celebrate the existing scholarship that we have, books and other publications, would allow people to see that participation here can lead to that kind of process. And that would be valuable, too, just to encourage people to participate in the group.
Other questions? I did have one. As we look towards kind of the future, I've been with the division for a few years, but just finally as a faculty member rather than as a grad student. How do you, or what I should say, what is the best way to incorporate kind of more students, either undergrad or graduate, into the program to make sure that the division grows? Do you see that there are any ways that are better that would help?
I would like to ask our students that. We have 3, 4, 5, 6, 7 students from the University of Northern Colorado. I would love to hear their opinion on that.
Repeat it.
Well, we're looking at how do we get students involved in the division to make sure it grows? What would you like to see as students?
Well, we all came to see Dr. Allen, who was our professor. But I think just more of an awareness. We're all pretty new to NCA, and it's a large or huge organization, and there's so much to offer. And so I don't know that we all really fully understand all the different divisions and different parts and pieces to NCA. So, for example, I just knew Dr. Allen was speaking today, and we came to see her and support her, but I didn't even know there was like this law division. And I find it fascinating, and I want to know more about it. So I think grad students talking to one another, sharing that information. But I wish that I wish NCA had some sort of a newsletter geared just towards students that just made you more aware of everything that there is, because even when you go on the website, it's overwhelming. And I know when I first signed up, there was this list of different things, feminist, and just these different things you could get involved in. And when I did sign up for membership initially, it was my first semester of my first year of a master's program. And so I still didn't understand, I still don't understand what all of these things are, because we haven't been exposed to things. And even in our master's program, it's like we get a little snippet of everything, interpersonal, small group, and critical theory and stuff. And so we're all just tasting everything right now and trying to figure out what is all out there and what where our passions are and what excites us to then go in that direction and learn more about it. So I wish NCA had a little bit more, and maybe there is a newsletter or something and I'm not getting it, but just something that's educating us, first of all, as to what NCA really is and all the parts and pieces that make it up, so that we have a better understanding. Because like I said, I didn't realize there was a lot of it. And when you're in grad school, you're so busy, it's not like you have time to sit there for a few hours and go through the website and read everything that's there. You're busy. And so just more information.
Yes, thank you. And this is Mary Powell. And it just occurred to me, this is, of course, a once-a-year event, but if we had a class that could be structured according to building up toward this conference, and it wouldn't have to be a new class, but you could incorporate into the logic of that class every evening a new phase of preparation for NCA and just have that run thematically through the class, then it doesn't become this once a year of here's the time to submit and then here's the time to attend, but rather something incorporated into the everyday logic of what we do.
I think a lot of us got involved in this group because someone invited us. And I think that's a big part of maybe all of our responsibility is to invite people based on things we see presented in other areas and other divisions or titles or other students we work with who are doing that kind of work. I really do think a lot of us, like I say, started because someone told us about it or encouraged us to present, or after maybe doing our first paper encouraged us to participate or join the leadership or do other things.
Yeah, you sort of stumble into it. That's unfortunate.
Right. And I think we do have to be
opposed to a neon sign.
Yeah,
here we are. Yeah.
It's outreach and it's one-on-one and it's face-to-face, and I think a lot of that has helped.
Any final questions for the panelists here? Well, again, I would like to thank you for your participation. It was a wonderful discussion. Thank you.